We are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we'll be hearing today are Justice Ariane Vuono and Justice Vicky Henry. The first 3 cases we'll be hearing are all criminal matters. We will take a brief recess of about 15 minutes after the 3rd case and then resume with the civil portion of our hearing list. The first case on our list for hearing this morning is case number 2020 P669, the Commonwealth versus FABIAN, Sevilla. Attorney Dame.
Thank you. Michelle Dame for FABIAN, Sevilla. May it please the court. I would begin with issue 2 in my brief about why I'm telling his mother or telling the jury that he told his mother what had happened. Only if the Commonwealth calls the recipient of the first complaint of a sexual assault as a witness may the complainant testify to the details of the first complaint and why it was made at a particular time. This testimony may not be used to prove the truth of the allegations, and the jury must be properly instructed both contemporaneously and during the final charge. If testimony that is not designated as first complaint testimony has no purpose other than to corroborate the accusations, then it is inadmissible. In Commonwealth v. Stuckich, the court stated that the naming of people to whom the complainant spoke with about the incident was akin to a parade of multiple complaint witnesses because the jury are likely and reasonably to assume that the complainant repeated the substance of his testimony to each person he spoke to.
So, counsel, where a criminal case is brought that involves a child, is it reasonable to think that the jury already knew that he told his mother about the allegations?
I don't think it would necessarily be that he had told his mother. He obviously, for it to come to a criminal investigation, he would have told somebody.
A parent or a guardian?
It could be, it doesn't necessarily need to be a parent or guardian. It could have been a teacher or a social worker, any number of people that could have been the recipient of that first complaint. Here he testified that he told his mother what had happened. He then testified that about a day after that, him and his mother left Mr. Sevilla's apartment. So it's extremely problematic because that testimony that they left shortly after shows that the logical inference would be that his mother believed him and got him out of that situation. So whether or not it would have been reasonable for a jury to assume that he had told somebody, I mean, of course, that's in all sexual assault cases. For it to come to a criminal investigation, the complainant would have had to tell somebody of their allegations. But again, the complainant is not allowed to say who they told to first unless the recipient of that first complaint is actually called as a witness and it's designated as first complaint testimony.
In this case, there was lots of other testimony to the effect that the victim told his mother, right?
At some point, I think the timing of how I think the timing here is what is concerning as to when the complainant said that he had told his mother, that it was after the second incident took place. It wasn't after the first incident, it was after the second incident, making it reasonable that the jury would have inferred that at the time he had only told his mother about the second incident that happened during the day and not what had happened the night before.
Let's also put this into some context. There was no objection.
There was no objection.
And so we're assessing whether there is a substantial risk of a miscarriage of justice. Separately from that, we, as you know, the rules have adjusted somewhat since Commonwealth versus King. There were a series of cases that made clear that it's not an absolute outright prohibition against any reference to multiple complaint testimony, correct?
Correct. There has to be other basis to admit it that's not to prove the truth of the allegations.
And in this case also, the statement that the victim made in his testimony did not describe the details of the assault, correct?
It did not. But the court has said, and it's Commonwealth versus Haggett, the appeals court testified that it was error for the victim to testify that she told her English teacher something happened since no first complaint witness was called. And there she did not go into the details of what she had told her English teacher.
Right. No, I understand all of that. I'm just trying to get to the extent of the concern that is presented by this situation.
Well, this particular indecent assault and battery, the one that happened during the day, is the only one that Mr. Sevilla was convicted of. The two indecent assault and batteries that were alleged to have occurred the night before, in which the jury did not hear testimony from YM that he had told his mother about those incidents, he was acquitted of those two. Wait
a minute. I mean, when you say the testimony was that the victim told his mother what happened, how do we know what portion of what happened was embodied in that statement?
I think it was reasonable for the jury to find that it only included what had happened immediately before his mother returned from work. So we heard that there was an evening where there were two indecent assault and batteries that were alleged to have taken place. And that was when Mr. Sevilla told YM, don't tell your mother. Then the next morning, we have this separate incident while his mother is at work. He then says when his mother comes home, he tells her what happened. Presumably, and I think it would be reasonable for the jury to infer that it was only what had happened while his mother was at work. And then she took him out of that environment. They left Mr. Sevilla's home. And that is the one indecent assault and battery, the only one that he was convicted of. And the court has said that where credibility is an issue, that improper first complaint testimony will likely result in a substantial risk of a miscarriage of justice. And that is when the testimony is not objected to.
Look, credibility is at the centerpiece of every one of these cases.
Yes.
And we have gone through various scenarios and identified some as giving rise to substantial risk and others where there is not.
Well, some factors that the court has said is if it's a jury waived trial, the court has not found a substantial risk of a miscarriage of justice. And also if the defendant is able to benefit in some way from the improperly admitted testimony.
Well, let's talk about that because as you are aware, the Commonwealth points out that the defense itself brought in multiple elements of testimony describing the victim's report of the assaults.
Correct. And this, what the defense counsel was able to bring in, he was trying to use that to his benefit. However, the particular testimony of the timing of YM told the jury himself on direct examination when he told his mother what had happened, that Mr. Sevilla was not able to benefit from. Again, the timing of that, and then right after that, him and his mother left the home, and that being the only indecent assault and battery that he was convicted of, I think does show that that did have an impact on the jury's finding. If there are no further questions on that issue, I'll move to issue 1 concerning the sufficiency of the evidence of the intimidation of a witness conviction.
Just one question on that prior issue. You were suggesting that the jury could have concluded it was only in what happened only related to the events of that day. Do we look at all the possibilities the jury could have considered, or do we look at the evidence in the light most favorable to one of the parties?
I mean, it could be really either way. My interpretation, what I think a reasonable interpretation is that again, you have 2 separate incidents, one which occurred at night, one which occurred during the day. The one at night, Mr. Sevilla told him, don't tell your mother. There was no testimony about that for the one during the day. And my reading of it would have been that him telling his mother what had happened would have been what had happened immediately before that she had gotten home from work, and not what had happened on a separate occasion the night before. So intimidation of a witness has 4 elements. 1, the possible criminal violation occurred that would trigger a criminal investigation or proceeding. 2, the victim would likely be a witness or potential witness in that investigation. 3, the defendant engaged in intimidating behavior. And 4, he did so with the intent to impede or interfere with the investigation or proceeding. Intimidation requires that you put a person in fear for the purpose of influencing his or her testimony. Here, the statement that Mr. Sevilla told YM not to tell his mother was insufficient to constitute intimidation. The jury did not hear any evidence of Mr. Sevilla's gestures, tone of voice, or body language from which they could infer that the words he spoke were used beyond a reasonable doubt to convey a threat. Even if the court finds that this statement was intimidating, there's an insufficient basis to find that it was made with the intent that YM not go to the police. There wasn't a rational basis to link YM telling his mother with YM telling the police. The situation is different than the case.
Wouldn't there be, excuse me, Counselor, wouldn't there be a link given his age? In other words, YM could not, most likely would not have been able to contact the police on his own.
He could have gone to, he could have though, or he could have spoken to a social worker or any number of individuals. The link did not have to be that if it had, that if he had told his mother that then it likely would go to the police. So the Commonwealth versus King,
Wasn't he 7 at the time of the alleged act?
I believe he was.
And the defendant was considerably older
Yes, he was.
and considerably larger.
Yes, and again, not
And
necessarily that this
it was charged with having committed a sexual assault against the victim.
correct, but even if you find that this statement was intimidating, it also has to be made with the intent that YM not go to the police, not just that he not tell his mother what had happened.
No, not directly to the police, but it's impeding the investigation, and telling his mother is the first step toward initiating that investigation, isn't it?
Doesn't mean it necessarily would get to that investigation though. So in Commonwealth versus King, where the defendant had told the victim, don't go to the news, it was reasonable that if the story was on the news and that meant that he had already gone to the police. There's not the same link in this case. Him going to his mother did not mean that he had already gone to the police or that the police would be contacted at all.
Well, we look at this evidence in the light most favorable to the Commonwealth, right? Because you're talking
Yes.
about sufficiency of the evidence. All right. So, and that being the case, would you disagree that there is a reasonable inference based on this evidence that a 7-year-old would tell his mother first, and that would be the first step towards going to the police?
But again, I think it would have been if him telling his mother meant that he had already gone to the police, correct? But it wouldn't happen that way. So it's like King said, by the time he had gotten to the news, if it was on the news, then it meant that he had already gone to the police beforehand. Him going
If
to
the
his mother.
defendant's intent is to prevent this from coming to light, and his first step is going to be to say, don't tell your mother, right?
Yes,
His overarching objective is to prevent the victim from revealing the fact of the assault in order to prevent or impede an investigation that would ensue from a report of the assault.
just from his mother finding out. He didn't say, don't tell anyone. He didn't say, don't go to the police.
Right, but we, as Justice Vuono pointed out, we look at this in the light most favorable to the Commonwealth. I want to talk just very briefly, because you're running out of time. You make the argument that the inclusion of the registration requirement in the conditions of probation would be beyond the judge's authority, and you cite Ventura for that. But my reading of Ventura suggests that that arose in a very different situation, where the original sentencing judge had relieved the defendant of the registration obligation, and it was at a subsequent revocation hearing that a different judge sought to reimpose that registration requirement as a standalone requirement. I'm having trouble understanding why this specific condition adds anything beyond the general condition of probation that requires compliance with all laws. Because in this case, the sentencing judge did not relieve the defendant of the registration obligation.
The registration can only come into certain statutory crimes. Intimidation of a witness does not fall into that. So if hypothetically the court was to reverse his indecent assault and battery convictions, his sexual assault, the only charge that is requiring him to register as a sex offender, then that probation condition could not stand, because he would no longer have that obligation to register statutorily. if the intimidation of a witness conviction was the only one that was upheld after an appeal, then
Understood, but suppose we, let's just suppose that we affirm that conviction. If we reverse it, of course, there would be a remedy to direct the removal of that condition. But if we affirm the conviction, why is that not a proper condition of probation?
because again, it can only, the registration only comes into certain sexual offenses.
Right, but one of them is the conviction that was placed against the defendant here.
Right. I mean, I guess it would really only apply whether or not the sexual assault conviction is upheld.
Okay. All right. Thank you. For the Commonwealth? Attorney Nguyen, you're going to need to unmute yourself.
We need to give the clerk a minute to get the timer up too.
Okay. You may begin.
Thank you. Beginning with the first issue with respect to sufficiency of the evidence with regard to intimidation of a witness, it's the Commonwealth's contention that when you consider the time, place, and circumstances of the defendant's actions in this case surrounding his statement to the victim that the victim not tell his mother, the jury could rationally and reasonably conclude in the light most favorable to the Commonwealth from those circumstances that a reasonable person in the victim's shoes who was 7 years old would have been intimidated. And secondly, that it was likely that if the 7-year-old victim told his mother would have taken that information to authorities. And I know there was some discussion with respect to sort of that being the first step to the authorities being notified of that information. So when you consider the timing of the statement, the victim had just been sexually abused by the defendant. When you consider the place of the statement, it was at the defendant's apartment while the defendant was alone with the child, and the child was particularly vulnerable. And then when you consider the surrounding circumstances in pages 35 to 37 of my brief, I do suggest that factors relevant to constructive force should also be factors in a scenario such as this case, where there's intimidation of a child by an adult perpetrator of sexual abuse, particularly when you're focusing on the circumstances in which the child victim is placed and the impact of those circumstances. So you can see that I do make the argument factoring in those constructive force factors in this scenario.
Let me ask you, if I may. You know, we often see an intimidation charge go together with an indecent assault and battery charge, because often an adult perpetrator will tell a child not to tell anybody. But most of those cases, there's a little something more. There's don't tell anyone or else. Either there's a threat regarding the safety of the victim, him or herself, or a family member, etc. And this case doesn't have that, it falls short of that. What do you say about that?
And I do acknowledge that in many cases, you might see a scenario where the perpetrator will say, don't tell your mother or I'll hurt your family. But, you know, from the case law, it does indicate that it's sort of a broad statute, and that specifically.
Right, but are there any cases that say that that only say don't tell?
Well, I think that, so I didn't find a case per se, but I think that it is very fact specific, which is why I make the suggestion that in a scenario where we're dealing with a child and an adult perpetrator, and you look at the facts of this specific case, that the fact that there was a great disparity in age between the two parties, the relationship of the defendant as a caretaker, babysitter, and his lack of sophistication, and the fact that this statement had just followed a sexual assault, that those circumstances, those surrounding circumstances,
that wouldn't be that unusual. I mean, usually the statement would follow, telling someone not to tell somebody would follow the events in question.
Now, certainly, you know, where there is that other piece, where you might see it in other cases where there's that actual threat. certainly that's a stronger scenario, but in the light most favorable to the Commonwealth, where the case law is that there doesn't need to be an overt threat. You can look at the circumstances, and in this particular charge, under the statute, which is fairly broad, the circumstances are really crucial. So my response to that is that I do think in a scenario like this, the constructive force factors are very important when you're looking at the surrounding circumstances. If there are any other questions on intimidation of a witness, I'll move on to first complaint. Okay, seeing no other questions. The Commonwealth's, I think the big picture argument is whether or not there was a substantial risk of a miscarriage of justice, there being no objection to the child's single leading statement. So when we analyze that sort of bigger picture argument, the first question is whether or not that statement in his testimony, whether that was an error, whether that constituted first complaint evidence, which in this particular case, the Commonwealth didn't offer first complaint evidence. And I do make the argument that it actually does not constitute first complaint because it was a vague statement and it did not articulate a sexual assault.
In context, I think it's certainly fair to understand the point of the victim's statement as being a report of the assault, isn't it?
So I can certainly see where one might argue that you can draw that inference, but I think that the case law does support the Commonwealth's argument that it doesn't necessarily constitute a first complaint because there's not a disclosure in that vague statement of an actual sexual assault. And I think
that treat statements that are awfully close to this one as being a first complaint based on the context. And I mean, what other than a report of the assault would the jury believe the victim had told his mother when the victim told his mother what happened?
Well, so it was such a vague statement, and there was some discussion of, the defendant's claim is that it was based on the second incident or during the nighttime. And the Commonwealth's contention is that we simply don't know what the child was referring to, what act.
Your argument is stronger in terms of the impact of the statement than that it is not
yes, and I absolutely acknowledge that that's the bigger picture argument. The fact that there was no objection to the statement, and the Commonwealth does discuss at length the fact that the defendant actually strategically introduced a great detail of first complaint evidence in the form of multiple hearsay from 3 witnesses in detail, and certainly that was central to his defense. And when you consider that defense and that strategy, you can certainly infer that the fact that counsel did not object was a strategic tactical decision.
Counsel said it was strategic, but help me out here. My recollection is that included within some of those other statements was in fact the very report to the mother that we're talking about here. Yes,
so you can also, if you recall my brief, I do make that argument that it's cumulative, and it's cumulative, and it's also less detailed. So the victim's testimony was very, very quick, very fleeting, very vague. It was a single statement, and really the majority of the defense's case was based on this first complaint evidence that they put forth. And so I talked about the tactical decision not to object, but I think also when you look at the jury's decision to acquit the defendant of 3 out of the sexual abuse charges, the indecent assault and battery charges, there were 4. They found him not guilty of 3 and only convicted him of 1. That certainly, you could reasonably conclude that the statement did not materially influence the verdict. So when you look at the totality of the circumstances, considering the cumulative nature of the victim's brief statement, in addition to the tactical decision to put forth a plethora of first complaint evidence by the defendant, and the jury's acquittal of 3 of the 4 sexual assault offenses, I would suggest to the court that there was no substantial risk of a miscarriage of justice. Are there any questions, further questions on first complaint? I did want to briefly touch upon Justice Green, your question with respect to the SORB requirement. You can see in my brief that I sort of concede that that perhaps the judge statutorily could not have imposed a specific
Right, I'm aware of your concession on the point, but when I read Ventura, it didn't seem to me, at least, to support the concession.
So I think it's very interesting. And I ultimately will defer to the court, but I do think it's interesting that sort of the court's take on it is that where there was a conviction on a sexual offense, that it's appropriate for the sentencing judge to then sentence as a part of the condition the statutory requirement that falls under the sexual offense.
I'm correct, am I not, that even if it were not included, the general conditions of probation include a requirement to comply with all legal requirements?
That's correct.
And
I hadn't thought of that.
If we did not have the situation that was present in Ventura, where the sentencing judge exercised her authority to relieve the defendant of the registration requirement, the requirement to register would survive and would be encompassed within that general condition. Adding it as a specific condition does not add anything in those circumstances, it seems to me.
I do see that, Your Honor. I do see how the general order for probation to follow all the laws of the Commonwealth would certainly encompass the specific statute. So I step back my concession. Were there any other questions with respect to any of the issues? Okay, there being no further questions, I would respectfully rest on my brief, and I thank Your Honors for your kind attention.
Thank you both. The case is submitted.
Thank you.
We are live.
We move to the second case on our list for hearing, case number 2019 P1236, the Commonwealth versus Silvio L. DEPINA. Mr. Bove, you may begin.
Good morning, Mr. Chief Justice. Your Honors, my name is Attorney Matthew Bove. I'm appointed counsel for the defendant appellant, Mr. Silvio DEPINA. The two main issues in this appeal is the confluence of the master crime index that was provided to the jury by the lower court judge, in addition to a great deal of contemporaneous acts that conflated to create a prejudice to Mr. DEPINA throughout what cannot be denied was an extraordinarily massive trial involving 41 indictments, 5 defendants, and multiple victims, where despite the lower court's interest in assisting the jury by creating this index, there was a great deal of opportunity for that index to be both misused in combination with the contemporaneous acts that were presented not only by each individual alleged victim as to themselves, but the other alleged victims as to other alleged victims involving indictments that did not involve themselves. In particular, while the Commonwealth is correct that—
Attorney Bove, the Commonwealth represents that the only difference between the index and the indictments is that the index named the charged offenses while the indictment set out the language defining each offense. Do you agree with that?
No, Your Honor, I don't agree with that.
Could you then explain what exactly was different?
Well, it's not so much the form, Your Honor. The Commonwealth is partially correct in that the listing on the index identifies the defendant, the crime, and the alleged victim. and whereas the indictments are a little bit more explicit, but the jury got to hold on to this index for the entirety of the trial. In the ordinary course, jurors aren't permitted to hold the indictments. While they are read at the beginning of trial so that the jurors understand what the elements are for each crime, here they were permitted to hold on to it and refer to it. And even though the indictments were read in advance and certain of the defining elements were explained to them, they could still look at the index and read assault and battery by means of a dangerous weapon, Sandal. And in that, with it in their hands, with the addition of the fact that the lower court refused to instruct the jurors not to take notes on this index, they were effectively given a checklist where they could compare what was being testified to what they had in their hands, whether it be.
In the absence of an inaccuracy, I'm struggling, I guess, to understand what's wrong with that.
Well, that's why the index. Well, excuse me. Let me begin again, please. In the ordinary course, a chalk or a summary of voluminous evidence is admissible. There's no arguing with that point, either in my brief or in the Commonwealth's brief.
Mr. Bove, I have to confess that if we had the entirety of these charges and defendants in front of us on appeal, in all likelihood, I would have asked my law clerk to prepare just such an index for my benefit before this argument, because it's the only way you can keep the things straight.
That may very well be the case, Your Honor, and that would certainly benefit yourself and the other members of the court. But you're discussing, excuse me, you're discussing an after the fact chart. This was.
I'm also talking about it. What the trial judge did here strikes me as being entirely understandable as a matter of discretionary case management for a complicated, multifaceted trial presented to the jury. And again, if there were some inaccuracy, if there was some distortion, if there was some manner in which this shaded the evidence adversely to the defendant, I could understand the concern. But I've laid my concern out on the table. I'm struggling to see what's wrong with this.
Well, Your Honor, it's also the confluence of the index with the contemporaneous acts. For example, Mr. DEPINA was only charged with one assault and battery using the sandal, yet multiple witnesses testified to multiple occurrences of his use of this act against the same witness over time. So with this index in their hands, the jurors may have selected different instances against a single victim.
So the Commonwealth says that the judge gave an instruction that they had to agree on the exact same act. What do you say to that?
There was a unanimity instruction, Your Honor. Mm-hmm. However, we don't know whether or not they actually agreed on any one particular act. For example, DG testified that he was subject to 3 or 4 of these, except he was not specific as to when any of them occurred. The indictment specified diverse dates, but he did not, there was no timestamp on any of those, one of which even allegedly occurred, according to EP and the witness Casado, after his recommitment. But he never specifically testified to which one. He just said that it occurred numerous times, 3 or 4 to be specific. So the jury.
How would that preclude the jury? How would that preclude the jury from determining that one of those events, all 12 of them, agreeing that at least one of those had occurred? I mean, what you're talking about here, I think, is just conflicting evidence that could be weighed by the jury, but it wouldn't prevent them from determining that a certain criminal act had occurred.
Well, that's where the prejudice comes in, Your Honor, because we don't know. While it is presumed,
well, the jury is presumed to follow the instructions
Yes, Your
as
Honor.
given.
they are presumed to do that. However, they could have agreed that the act happened, but just not the specific one. Since a juror can accept all
Well,
known.
they could have, but what? But that's not really the issue, right? They could have. The issue is whether or not, given the instructions, or as the Chief Justice pointed out, some sort of other inaccuracy with respect to the chart or the index itself, that was likely to have happened. And if it was likely to have happened, you have a better argument on prejudice, right? But
Yes.
could have happened is sounds like a little bit of speculation.
I don't believe so, Your Honor, because given the sheer volume of the contemporaneous acts as against each alleged victim, there was so much to unpack in this trial, whether it was either a specific victim testifying or other alleged victims testifying to another victim being subjected to this treatment. And given the sheer number of indictments, the sheer number of defendants, the sheer number of victims, that confusion could very well have made its way into the jury, even with this check.
I think the risk of confusion would have been greater without the index, quite honestly.
So counsel, was there anything that was inaccurate in the index?
No, Your Honor.
Do you agree that the judge repeatedly instructed the jury that the index was not evidence?
Yes, but that was not the point. The fact that that was not evidence was made clear by Judge Locke, and there was no question as to that. The problem is that they had it, they could look at it, they could refer to it, which is something that's not ordinarily allowed for a chalk throughout an entire trial or a summary of voluminous evidence through an entire trial. These are tools that are used by a proponent of the evidence to sum up evidence that a particular witness has provided, or is even in fact built by a particular witness based upon.
So you argue that the judge providing the index somehow put the judge's view of the defendant's guilt before the jury. So first of all, does the jury have any idea what the origin was, or they just know that the judge provided it, right?
The
They don't know.
I'm sorry, please continue.
Yeah, they don't know if the parties proposed it, right?
No, they only know that they were given this document.
So what impact did it have then when the judge entered required findings of not guilty on some of the charges then and provided a revised index to the jury?
Well, as far as I can tell, the judge instructed the jury, or as far as I recall, the judge instructed the jury that the newer document had these crimes removed because the judge found insufficient evidence as to those particular charges. That would, in my estimation, permit the jury to believe that certain evidence was not admitted, but would leave everything else for them. And in the case of the charges that were directed out, at least as to Mr. DEPINA, either the alleged victim did not provide an element of that crime in his individual testimony, or it was not provided by another witness who had seen or at least observed some of the crimes that were directed out. An argument can be made, and the Commonwealth, in fact, made this argument, that the argument for prejudice caused by the index, as well as the contemporaneous acts, somehow lessens the prejudice that Mr. DEPINA would have suffered based upon the two erroneous admissions. Nevertheless, even though the jury acquitted Mr. DEPINA on 3 charges in regards to DG, those 3 charges occurred off-site. Those were at a different facility. So the fact that they did not believe DG as to the charges that arose at the Metro Revocation Unit doesn't affect the prejudice that Mr. DEPINA would have suffered from the rest of the testimony regarding what occurred at Casa Isla. And that's really where this massive amount of contemporaneous acts caused him that prejudice. Because if all of these individual witnesses are testifying that he is committing all of these alleged acts against multiple people in the same way, in the same space, for the same reasons, even if they don't believe that one of them occurred, or two of them occurred, or even three of them occurred, the piling on of this evidence shows simply, or established simply, the propensity to do it. And the fact that the Commonwealth kept relying on the idea or the phrase, the orange chicken team, further prejudiced Mr. DEPINA's case.
So counsel, I do have a couple of other questions and time's running short.
Yes, Your Honor.
Do you agree that the standard of review on sufficiency as to whether the defendant committed the crime of assault and battery on AB2 is substantial risk of a miscarriage of justice?
No, Your Honor.
So you believe that was preserved?
I do.
And do you have a cite for that?
A citation to the record or a legal
Yeah.
authority?
I do not. The Commonwealth maintains to the contrary, so.
I will provide that citation following the argument, Your Honor.
On the sufficiency of the evidence on the threat to AB2, in the light most favorable to the Commonwealth, did the evidence show that the defendant warned AB2 not to say anything about the assault and that he had AB2's home address?
That was the testimony, I believe. However, the problem with, I'm sorry, I'm looking at the wrong threat. I apologize, Your Honor. There was testimony that DEPINA admitted that he knew where he lived.
And was there also testimony that DEPINA had told AB2 the story of Isaac, who had faced retaliation for snitching?
Excuse me.
Well, let me rephrase
No,
that.
AB2 did not directly testify that DEPINA told him about Isaac, but that he knew of Isaac and had heard about Isaac. So nor did he identify an intermediary to communicate that to him under the threat standard. And I see that time is up.
So I take it you think that it's not sufficient that the defendant warned AB2 that he had his home address?
Saying that, yes, but just saying that without more, in my opinion, is insufficient.
So if a person said, I know where you live, that would not be enough?
Not without the other circumstances regarding what alleged crime would be committed or what interference that individual would perform.
Thank you.
The defendant will rest the remaining arguments on his brief unless there are any further questions.
Thank you. For the Commonwealth?
Good morning, Your Honors. Paul Lynn for the Commonwealth. I'm only going to briefly touch on the first argument. As I argued in my brief, the index contained nothing more than what was contained in the indictments. It was actually just more succinct than the indictments because it didn't contain all of the language defining the charges. The judge repeatedly instructed the jury that the index was not evidence. And as I say on page 19 of my brief, this is quoting the December 6th transcript at page 126, it's not a checklist, which is exactly the concern that the defendant had. And the issue regarding both the index and the extraneous acts is that all of this information came from the same source, and that is the residents themselves. And no reasonable juror could have failed to realize that the central issue at this trial was the credibility of the residents. The Commonwealth argued that the residents were credible. The defendants, all of them, argued that the residents had lied. They'd made up the orange chicken because they figured out it was a way to get things they wanted, to get out of the facility and to get back at the guards who had made their lives unpleasant. So that was the issue. There was no chance that the jury would say, well, here's this document, so all the charges must be true. It's not possible. And I would point regarding the extraneous issues, the judge was extraordinarily careful in exercising discretion, prevented the Commonwealth from introducing several incidents and strictly limited the extraneous evidence to incidents that were inextricably intertwined with the charge incidents, or incidents that a witness, one of the residents, specifically said had caused him not to report these incidents. Unless the court has any further questions on that issue, I'm done with that. Are there any questions regarding the threats issue, the sufficiency of the threats evidence?
Well, do you think it would be enough if the defendant had said to one of the victims, "I know where you live"?
I think it would have to be more than that. You'd have to say, that would certainly be a very close call. But the fact he says, "I know where you live," and there's this guy Isaac, and I just checked, the AB2 did testify that the defendant told him about Isaac and told him what had happened to him if he snitched. Also, as I put out in my brief, AB1 testifies that during the orange chicken attack on AB2 in the cafeteria, the defendant says, AB1 testifies that the residents are reluctant to join in striking AB2. And the defendant, DEPINA, says in those circumstances, with AB2 right there lying on the floor, if you don't participate, you'll get orange chickens yourself. So he knows that this is how it works, that if you don't participate, you're going to be physically assaulted. And that's a threat.
Do you agree that AB2 never explicitly testified that the defendant threatened to inflict this orange chicken assault on him?
That's correct. AB2 did not say what AB1 had said. So he never, there is no testimony from AB2 himself that he heard that threat. If there are no further questions, the Commonwealth, go ahead.
Yeah, I mean, the defendant argues, notwithstanding your statements about intertwinedness, that the Commonwealth could have easily excised the assaults against, I think, 3 witnesses who were not victims in the case without affecting its case. I'm not saying the names because I assume they're also minors.
Correct.
What do you say to that?
I'm saying it was well within the judge's discretion to admit these incidents because they were intertwined with the charged conduct. The 2 of them occurred at the same time. There was confusion, admittedly. There was an incident that AB2 initially testified it happened at the same time, and then it came out later in his testimony that it had been confused and it hadn't. But by that time, it had already come in. The judge could have stricken it, but again, I come back to the fact that it's a matter for the judge's discretion, and the judge exercised his discretion with extraordinary care to make sure that the Commonwealth did not pile on, but only these issues that were directly relevant to the case came in. And when this confusion regarding AB2's story and when these assaults happened came in, the judge said, this is for the jury to sort out. This is a credibility matter. It probably undermines AB2's credibility because he said at first they all happened at the same time, and then he said, oh, wait, that was a different incident. So again, that was within the judge's discretion not to strike that testimony.
The defendant also argues that AB1 never actually was subject to one of these orange chicken assaults. That's a reference to these orange sandals, right?
Correct, Your Honor.
And you agree that AB1 never received an orange chicken assault?
I don't believe he was, any of the defendants were charged with that, or at least not this defendant, if you'll hold on just a second. I'm sorry about this, Your Honor. I want to make sure I'm accurate. Yes, he was, AB1 was charged only with, or excuse me, AB1 was not charged at all with anything except what got him into the facility. But the defendant was charged only with the indecent touching of AB1. So yes, you are correct, Your Honor.
Okay, so he was charged with indecent touching, but not with an assault and battery?
Not with an indecent assault and battery, but not an orange chicken, Your Honor.
Okay. So he then argues, well, because AB1 never received one of these orange chicken assaults, that any common scheme or state of mind related to delayed disclosure would have been completely irrelevant. What do you say to that?
Well, the threats have the same effect. First of all, I don't believe, let me double check this again. I am sorry about this, Your Honor.
We understand.
Yes, as he was not convicted. This defendant was not convicted of a threat against AB1. So I'm not sure how that's relevant.
So the common scheme or state of mind relates to the threat?
I'm not sure what you're asking me, Your Honor. I'm sorry.
Well, he's arguing that because AB1 never received one of these orange chicken assaults, there wasn't even a charge, let alone a conviction.
Correct, Your Honor.
That the Commonwealth's argument that there was a common scheme or state of mind that was the reason for the delayed disclosure of the assaults would have been irrelevant. This is what he argued in his brief. I'm just trying to understand your response.
Well, my response is the defendant wasn't charged with that regarding AB1. So, I mean, the evidence came in of a common pattern that these defendants were inflicting orange chickens on multiple residents. Almost all of those incidents, except the ones regarding the witnesses who weren't named in the, excuse me, the residents who weren't named in the indictments. Most of these all of the rest were charged, that were charged A and Bs. So I'm apologize if I'm being dense, but I don't understand what the problem is.
He's just saying that I think he's saying that a lot of these uncharged bad acts couldn't come in as a common scheme or plan.
I say because AB1 wasn't
assaulted.
This wasn't alleged to be the victim of an orange chicken. I don't think it has to be against each separate victim in order to be evidence of a common scheme. The evidence came in as to the incidents which were the basis of the charges, and then these additional incidents came in as evidence either of something that happened contemporaneously with these charged incidents, or that were witnesses explicitly testified were the reason that they didn't come forward earlier. They were admissible in the larger sense because they were a common scheme, but those were the real specific purposes for which this extraneous evidence was admitted.
All right, I just feel the need to clarify for people who are viewing, because we don't go into factual background. When we're talking about orange chicken, we're not talking about a an ethnic dish. We're talking about
No.
hitting someone with an orange sandal, right?
Correct.
Okay.
If there are no further questions, the Commonwealth will otherwise rest on its brief.
We are live.
The next case on our list for hearing is case number 2020 P296, Antonio Medeiros versus the Commonwealth of Massachusetts. And just as a reminder, we will take a brief recess following the conclusion of the argument in this case. Mr. Stiles?
Thank you. Good morning, justices, and may it please the court. I, Ethan Stiles, appear today for the appellant Antonio Medeiros. Mr. Medeiros has appealed the finding that he remained a sexually dangerous person because the qualified examiners and the Community Access Board in this case equated criminality with mental abnormality and personality disorder. A qualified examiner must provide a clinical basis for distinguishing the STP from a typical criminal recidivist, and we cannot commit individuals on the basis of just because they commit multiple sex offenses alone, because that does not meet the standards of the Supreme Court as held in Kansas v. Hendricks and Kansas v. Crane.
So,
And
counsel, the Commonwealth is arguing that the standard of review for us here is substantial risk of a miscarriage of justice. Do you agree with that?
Yes, but in this case, my argument is that there was a substantial risk when the clinical basis broke down because the psychologists did not follow the DSM requirements for the diagnoses that they've made. Now, as he's a trained psychologist,
Doesn't that would that go to the way the evidence? In other words, the Commonwealth's witnesses here did specify certain specific mental conditions that they allege or testified in any event that your client suffers from.
that yes, that they did indicate that he suffered from certain mental conditions. That was the basis for their opinion as to why he deserved to be committed as a sexually dangerous person. However, I would suggest that the basis for those is wholly lacking, because ultimately the experts did not follow the guide that they use, and that they all.
That sounds like fruitful territory for cross-examination and impeachment. But as Justice Vuono points out, I mean, it seems to me that those arguments go to the weight or credibility of the evidence and not its sufficiency.
I would suggest to that the statute and the case law require a finding of mental abnormality or personality disorder. And in these cases, the experts always point to a DSM abnormality, whether it's pedophilia, antisocial personality disorder, or paraphilia, or something similar. They can point to a diagnosis and say, here he is, and this is how he meets the diagnosis. These are the criteria, and this is what we see in the facts, saying A, B, and C are met, therefore he has pedophilic disorder, or therefore he has antisocial personality disorder. But in this case, the facts did not support those diagnoses. And without the diagnoses, you have nothing more than, I think he's dangerous, and therefore it should be committed, which is clearly not sufficient.
It's more than I think he's dangerous. They also, as Justice Vuono observed, they testified that he suffered from a mental abnormality.
Yes, they testified to that, but their opinion just...
And the jury are entitled to credit that testimony, correct?
Not in this particular case, I would suggest, Your Honor, because their diagnosis did not meet even the standard that was required for those diagnoses.
Well, again, it seems to me your trial counsel is certainly entitled to challenge the basis for those opinions through cross-examination or impeachment. Yeah. But to say that the opinion is inadequately explained for it to be entitled to credibility by the jury, I think you're sort of up against a great weight of our jurisprudence in suggesting that we are going to discount the jury's assessment of credibility of an expert's opinion.
I don't even think you need to get into weighing credibility if they say this. If one of them says he's a pedophile, but the evidence is clear that there's something missing here to call him a pedophile, and we might as well start with that one. that Dr. Rouse Ware, one of the qualified examiners, was the one who said he suffered from pedophilic disorder, and these are the reasons why. But she had to stretch because there was only one offense, one day, involving victims that were prepubescent, something that is required for pedophilia disorder. And in that case, she had to stretch by saying, "Oh well, we could look at his son, the offense against his son." And
Why is that a stretch?
because in this case, she said, well, boys develop more later than girls, and at 14 years old, he may not have yet shown the secondary sexual characteristics of puberty, which I would suggest is nothing but wholly pure speculation without any evidence to what the son looked like. Or
Once again, I mean, I'm sorry to keep beating the same drum, but it sounds to me as though you're arguing weight and credibility rather than sufficiency.
Well, no, I do argue sufficiency because
No, you're calling it sufficiency, but it seems to me that the challenges you're lodging go to weight and credibility rather than sufficiency.
In this particular case, the Commonwealth still has the burden of proof in these cases, and it still must meet the element that he suffers from a mental abnormality or personality disorder.
And an expert's opinion to that effect is entirely adequate to meet that burden, is it not?
If they follow reliable standards, then yes. But in this case, I was just that they did not, and they suffered.
Are you trying to say that the opinions offered weren't really ever admissible because they didn't meet the scientific standards?
I mean, obviously, we don't know what we can only, there was no motion to strike. There was no motion to strike here, and no dog or Lanigan. But ultimately, when you
are admitted, they are evidence.
Yes.
And the jury may choose to believe them or not believe them. You're suggesting that the jury could not choose to believe them because they were not credible, were not reliable. That's not something that we ordinarily entertain as an appellate argument.
Well, in this case, I think the court should look at the actual bases for these opinions and see that they simply just don't hold, that they just simply don't hold up and cannot be deemed sufficient.
No rational jury could believe this testimony.
Well, the jury is not given the guidance that this court does that this does review, but ultimately it's for this court to say whether this evidence would have been sufficient for a jury to believe it. And I would suggest, again, I think I've already discussed the reason why the pedophilia diagnosis just simply doesn't hold water.
What's the closest case that you have for us to review that supports the notion that that an expert's opinion may be disregarded, even though facially sufficient, because it did not have a sufficient basis? Again, where that was admitted without objection at trial.
I do not have a clear case that says that, but there have been instances where the court has put limits on the availability on what an expert can testify to.
Oh, certainly there are cases that identify grounds for the trial judge to limit or exclude even the expert's testimony. I'm not talking about that. I'm talking about where the testimony comes in without objection and facially satisfies the required legal elements, and then the challenge is made on appeal that the opinion was unreliable.
I cannot think of a specific case.
Neither can I.
I'm sorry.
Neither can I.
However, nonetheless, this court, does still have the obligation to review to see whether the evidence was sufficient. And my argument is that these opinions were based on diagnoses, and the diagnoses were not applied appropriately. And without it, you're missing an element, a key element of the Commonwealth's case.
So, how many experts said he had the mental disorder? Was it 2 or 3?
Let's see. They testified to different mental disorders. The qualified examiner, Dr. Johnson, I believe, said he had antisocial personality disorder. Qualified examiner, Dr. Rouse Ware, said he had I believe she said he had pedophilic disorder, and the CAB board testified that he had unspecified paraphilic disorder.
And any one of those, if believed by the jury, would be sufficient to warrant his conviction, correct?
If the evidence was there to support those diagnoses, then yes, one of those would have been sufficient under our case law.
So I've heard you say that one of them wasn't supported because we don't know what the defendant's son physical condition was when he was 14, but the other assault involved 3 different girls that were definitely under 14, or at least 2 of them were under 14.
Yes.
Right?
In that particular case, yes, there was an assault. However, it was against 3 girls at one time, and the definition of paraphilia generally requires a recurring instance over 6 months. So what Dr. Ross-Weir did was she simply pulled at from the later assaults and said, well, here it is. And then she also pointed to some photographs found in a cell several years ago, also to show that. But
and assuming that we didn't have the assault on the son available, would it be sufficient to have photographs of the kind that were in this case that he had?
No, I would suggest not, because there's nothing. The photographs are not child pornography. They were taken from a magazine or a catalog, and they were clips of.
Those were the photographs he managed to get while he was in the treatment center, and that showed children dressed in adult clothing.
Yes, either adult clothing or bathing suits. I believe I've received it, Brett. But anyway, there's nothing innocuous about that. No, and not criminal activity to possess those and it's only really a violation of the rules. But again, without any, and there's nothing to suggest they were particularly sexually provocative, as we may have noted in recent times. So with that, there's nothing there for the pedophilia diagnosis. And as far as the antisocial personality disorder goes, that was based on that requires instance of conduct disorder prior to 15 years of age. And they had to rely on Mr. Medeiros' relation that he was jailed by the Cuban authorities for refusing to work or breaking machinery. But I would suggest that criminality has the whiff of political crime. And while that diagnosis may receive a vote of thanks from the party's central committee or a mention of the analyst's name at the next Politburo meeting, I would suggest that it is not supportable in a society that actually values freedom. So without that, we do not have antisocial personality disorder, and it should not have been used. And if we're dealing with antisocial traits, essentially, the SJC quoted in one case that up to 75% of the United States prison population may be characterized into having some form of antisocial issues. So that alone, I would suggest, is not enough to raise the standard of that this person has a serious mental illness or disorder that's going to distinguish him from the general prison population. And that case was called COMMONWEALTH versus Johnson at 46 Mass 51. It's from 2020. And the CAB also gave an opinion, and to the extent we need to reach it, they called it unspecified paraphilic disorder. And they said something, and they said that well, he commits offenses against multiple non-consenting victims, and the victims are diverse. And I would suggest that, again, that's just really just calling he commits sex offenses by a different name. There's nothing particularly special. And obviously, if you're dealing with sex offenses, they are always against unconsenting people. That's sort of the nature of the beast. And the diverse victim types that do not seem to come anywhere near the kind of paraphilia suggested in the DSM, such as zoophilia, corpophilia, or necrophilia, or telephone scatologica, essentially very unique and distinctive fetishes or paraphilias. So in that case, we are left with no diagnoses worth any weight to bring to a jury. And ultimately, if the child, obviously this court is responsible for determining that they are not sufficient and should overturn Mr. Medeiros' judgment of commitment. And if there are no further questions, I will rest on the brief.
You're muted, Chief.
Seeing none, thank you. For the Commonwealth?
Yes, may it please the court, Jean Holmes for the Commonwealth. There's no cause to disturb the jury's verdict in this case as it relates to Mr. Medeiros, who remains a sexually dangerous person as the jury found. There is no showing of any substantial risk of miscarriage of justice in this case. In this case, we had the Commonwealth called 3 witnesses. One of the witnesses was a member of the Community Access Board, and she indicated and opined and testified as to the opinion of herself as well as the other members of the CAB that in their opinion, Mr. Medeiros had both a statutory personality disorder as well as a statutorily defined mental abnormality. In addition, 2 qualified examiners were called to testify on behalf of the Commonwealth, and each of those qualified examiners also testified as it relates to their opinion as to Mr. Medeiros' mental conditions. As it relates to Dr. Johnson, she testified that he has a statutorily defined personality disorder. And as to Dr. Rousweir, she's testified that he has both a mental abnormality, statutorily defined, as well as a personality disorder. The jury had all of that evidence before them, and based upon all of that evidence, in addition to other evidence offered by Mr. Medeiros that were contrary opinions, the jury decided this case, and respectfully, the evidence supports their finding that there was evidence as well as reasonable inferences to prove beyond a reasonable doubt the Commonwealth's burden in this case that Mr. Medeiros remains a sexually dangerous person.
So your learned colleague argues that one of the opinions about a mental disorder was based on, had to be based on the disorder that the expert picked, had to be based on conduct that the defendant committed before age 15, and that the conduct relied on was, somehow stopping the equipment at the plant at in Cuba, and that we really shouldn't rely on that at all in assessing personality disorder. So what do you say to that?
Well, particularly Dr. Johnson explained in her testimony as well as in her report that it wasn't just that one incident that she was looking at. She was also looking at other factors of conduct disorder as it related to Mr. Medeiros, which included him dropping out of school at a very young age. There's some variance, but somewhere around 12 years old. That in addition to that, Mr. Medeiros had reported to her that he used aggression as a means to handle his emotions as a youth when he was younger. So the fact of that incident at the factory where he was working was but one factor that was considered by all of the witnesses as it relates to the antisocial personality disorder, which required a conduct disorder finding. Notably, in Mr. Medeiros' case, he called his own expert, Dr. Brown, who opined that in his opinion, with all the evidence and facts that he had in data, that Mr. Medeiros had and suffered from antisocial personality disorder. And Dr. Brown even tied that to his sex offending by saying that the etiology of his sex offending was the antisocial personality disorder that he found. So although counsel has made much of that lack of evidence to suggest that that was for the jury to decide, and certainly those questions were all on cross-examination asked by the witnesses as it relates to the potential lack of evidence of the conduct disorder, but respectfully, the jury found that there was that evidence in regards to crediting it. Notably, I would also point out that the law clearly states that there is no DSM-5 diagnosis that's required. And Mr. Medeiros in this case is stressing all of the DSM-5 points as being the points to be made. But if we look at the case law clearly states that a DSM-5 diagnosis may be considered by the jury, but is not necessarily required by the jury. So although counsel has focused on that, I respectfully suggest that that is not the focus. And in fact, the jury is instructed and was instructed in this case that a DSM-5 diagnosis is not required. So the antisocial personality disorder that counsel talks about, as well as the other diagnoses that he talks about are all DSM-5 diagnoses, which the jury was told they may consider, but were not required to find. And if there's no further questions, I'll rest on my brief.
Well, what about the other expert he's challenging, saying that the expert said that, well, we can count the assault against the son because he was 14 and he may not have gone through puberty at that point. Was that grounded in any evidence?
Dr. Rousweir and her resume is part of the record, has a good deal of experience as it relates to the development of children. Her credentials were not challenged, nor was her testimony as it relates to that, to the extent of that it was not admissible or it was not viable. Counsel did not bring a motion in limine in regards to that, even though counsel knew that that would be her testimony and her opinion prior to trial. And as it relates to the testimony, Dr. Rousweir explained that it wasn't just the children that he sexually assaulted, but it was also the pictures that he was found with. Those were pictures that he had organized and folded and taped in such a way so that they appeared to be children. And I would note to the court that the evidence was that the other men that were in his treatment group indicated that the pictures were provocative, that they viewed them as provocative. They also viewed those pictures as triggering their pedophilic interests. And when Mr. Medeiros was confronted with that, he said that he thought the pictures were sexy. So although there was testimony, and again, the jury was free to credit it or not, that in Dr. Rousweir's opinion, all of the children under the age of 14 were either prepubescent or on the or on the cusp of pubescence, and that was based upon her experience that children develop sexually in a different way, and in a different way, including the fact that in her experience, boys particularly oftentimes do not mature sexually until 15 or 16. But add that to the pictures that other men who are in that sex offender group say are triggering their pedophilic problems, and Mr. Medeiros' response that they are sexy. I respectfully suggest that the jury had sufficient evidence as it relates to the pedophilic disorder. I would also note that the CAB found what was called an unspecified paraphilic disorder, and that was related to not only just the children, but the adult, and the fact that Mr. Medeiros was involved in sexually aggressive behavior against both age groups. If there are no further questions, I'll rest on my brief.
Seeing none, thank you both for your argument. That concludes the argument in this case. The case is submitted, and we will take our morning recess.
He drowned at the high school August 6th of 2012. Prior to the filing of this complaint, the city alleged Eddie was an unauthorized user. He drowned at the high school August 6th of 2012. Prior to the filing of this complaint, the city alleged Eddie was an unauthorized user. He drowned at the high school August 6th of 2012. Prior to the filing of this complaint, the city alleged Eddie was an unauthorized user. He drowned at the high school August 6th of 2012. Prior to the filing
be having a loop.
We are experiencing some technical difficulties here. Why don't we suspend this here?
We're live again.
Okay, we experienced some technical difficulties previously. We will resume at the beginning of the argument in case number 2019 P1736, the estate of Eddie K. GAYYEAN versus the city of Lowell. Ms. Murray, you may begin.
Sure. Tamara Murray for the plaintiff appellant. Eddie GAYYEAN was a fairly new student at the Lowell High School. He was there to sign up for summer classes. He entered the pool and drowned on August 6, 2012. Prior to the filing of this complaint, The city alleged Eddie was an unauthorized user, and in their defense, in defense to their allegation in count number 2, was to show that the city owed a duty to Eddie under the child trespasser or attractive nuisance. The issue here in this case is whether or not Eddie was an adult trespasser or a child trespasser under Mass General Law 231, Chapter 2, General Laws, Chapter 231, Section 85P. Here, we contend that Eddie was a child trespasser.
You do agree he was a trespasser?
I agree that he was a trespasser in the pool. He was authorized to be in school. However, into the pools is the same area, but there were signs alleged to be posted. So he trespassed into the area of the school.
Now, the motion judge, this was decided on summary judgment, the motion judge concluded the child, in fact, was a minor. He was 17 years old. But the child trespass statute does not apply in circumstances where a person of ordinary intelligence of the age and sophistication of the child would have known or appreciated the danger. And the motion judge concluded that the 17-year-old, who I believe the evidence is uncontested, could not swim, would have understood the danger in this situation.
Yes, and that's where I disagree, that he was an adult trespasser and he should have realized or appreciated the risk. This is a child that just migrated to the United States from Liberia. We do not know whether or not he was used to swimming pools or not. I believe that this is an issue of fact for the jury to consider whether or not he knew and appreciated the dangers of a swimming pool. The case in chief here is Cateron versus Royal Park in the brief, page 21, where it says that that the jury are supposed to be trusted with the finding that a trespasser is a child under section 231, section 85P. So here, there's a reason why there is Mass General Law 231, because children do not know how to make decisions on their own. And that's the reason why, if they did make good decisions, then we would not have this law to protect children.
Well, there are certainly bad decisions made by 18 and 19-year-olds as well. I think the Calderon case that you cite in your brief did not actually make that determination. As I read the opinion in that case, the panel affirmed the lower court ruling because the appellant did not provide a record, and therefore there was no basis to challenge the factual determination made in the lower court.
Correct, Your Honor. However, it did state that for a child to determine whether or not a teenager is a child who appreciated the risk, that the jury should find. The jury is the person or the people who should determine whether or not, based on circumstances, experience, whether or not they're a child or an adult.
In this case, the judge noted in her memorandum of decision, which of course we review de novo, but that there were no specific characteristics about this individual that would establish that for some reason or another he did not understand the risks involved. That there was nothing specifically alleged with respect to that. What do you say to that?
And that's where I believe that testimonial evidence from the decedent's parents and friends would come into play, whether or not there were special circumstances.
No, but I guess the point is that there is it's incumbent on the plaintiff to present that evidence at the summary judgment stage in order to establish that there is a triable question. the judge made the observation that there was no evidence to suggest that this 17-year-old would not have appreciated the danger of a swimming pool to someone who didn't know how to swim.
Correct. Now, the gravamen of this case really rests where he is from another country. That is one of the aspects here, that we don't know whether or not he appreciated the risk of a pool.
Was there any evidence put before the motion judge on summary judgment to suggest that he did not?
No, there was not. And
so it seems to me that in the absence of that, we would take the ordinary expectation that he would be apprised of the ordinary knowledge of a 17-year-old, and the motion judge made the determination that an ordinary 17-year-old would understand that a swimming pool posed a risk of drowning if you can't swim.
Well, that's correct, Your Honor, but however, this case is different. This is not an ordinary 17-year-old. This is a child that came from Liberia, and there is no knowledge whether or not he is aware of the dangers of a swimming pool, whether or not they have swimming pools in Liberia.
But in order for that to be a question for the jury, there would have to be evidence to put before the jury on that question, and you have to make a proper of that evidence. I mean, it's not enough to simply speculate that he didn't.
So the argument here is that the jury could infer that, because I don't believe that anyone really could speak to the fact that he knew or appreciated the risk of a swimming pool, being as he's no longer here. His parents hardly knew him because they left him when he was a child. So based on the evidence or the statements, testimonial evidence, I believe that would come out that he did not know how to swim.
Well, let me ask this, I guess. I haven't poured through the detail of the summary judgment record. Was the fact that he had only recently moved to this country from Liberia, was that in the summary judgment record?
Yes, Your Honor, I believe so.
And was there any attempt to argue to the motion judge that that his recent arrival would make him stand differently in terms of his ability to appreciate the danger of a swimming pool?
I believe that was argued, Your Honor. I was not present at that summary judgment hearing, but that was in the brief, that due to the fact that he just migrated, he did not appreciate the risk of harm.
Was there any evidence to substantiate that argument?
There was no evidence to substantiate that.
Okay, so in order to create a triable question of fact, there would need to be some evidence, it seems to me.
That is correct, Your Honor. However, it is noted in the record that the defendant did not know how to swim,
making him all the more aware of the danger of a swimming pool.
And there were also violations. The city of Lowell or the high school were in violation of several items, such as the marking of the swimming pool. So therefore, we don't know whether or not he appreciated the risk, because we don't know whether or not the target areas were 12 inches to 9 feet. They were improperly marked and they were cited. The city was cited for those violations. So
does the record indicate whether he was dressed for swimming when he was found, or if he was in his street clothes still?
The record disclosed that he was in his undergarment. So he took off his street clothes.
Now that was in the police report, correct?
That is correct.
Right. Okay. Which the judge did not rely on.
That is correct.
Right. And I think the police report said that his clothes were actually folded on a bench or something like that, that they had been, do I remember
that they were
correctly?
placed, yes, I believe, Your Honor. So he took his clothes off, but the pool was not properly marked as to the height or the depth. So if, that also speaks to the recklessness of the school department. So if
So even if
court
he's, even
here-
if he's treated as, your argument is even if he's treated as an adult trespasser, the city violated its duty because it was reckless.
Yes, Your Honor. I firmly believe that. And the police reports also speak for itself that the doors were always kept unlocked. In addition to that, there's an affidavit proffered by the defense from Patrick Harrigan that stated that he was not aware of any issues regarding trespassers in the summer of 2012. Now, the city has claimed that Eddie GAYYEAN was a trespasser, yet this affidavit is stating that there was no trespasser. They're unaware of any trespasser, including Mr. Eddie GAYYEAN. So
That's
therefore,
the custodian who submitted that the head custodian that submitted that affidavit. Am I correct?
yes, Your Honor. So you can't have it two ways. It's either there was an incident or there was no incident at all. They're saying here, there was no incident in the summer of 2012. This is, I'm not saying that this is a lie, but it is not true because we do know that an incident did occur in 2012. Eddie GAYYEAN did pass away in the swimming pool.
I interpreted that as to mean that there was no other incidents. That was how I interpreted the affidavit.
Well, it wasn't specific enough. So that I interpreted the other way.
All right.
I'm sorry, Your Honor. In addition to that, due to the fact that the school was put on notice that the locks were always broken, the doors to the swimming pool were unlocked, they did not fix it. They did not remedy the situation. That's willful, and it was reckless conduct on the part of the city. So whether or not Eddie GAYYEAN was a child trespasser or an adult trespasser, the city failed its duty of care to a foreseeable plaintiff. In addition to that, they breached their duty of care to Mr. Eddie GAYYEAN. I believe it was the memorandum, the Massachusetts Department of Elementary Secondary Education state, and this is in the appendix 114 to page 121. According to the Department of Education, it would appear the school would be strictly liable for Eddie GAYYEAN's death because the policy of the school must take necessary steps to keep the pool locked and secure at all times. At all times. So they have a memorandum stating the same. So they would be strictly liable to foreseeable plaintiff. And remember, Eddie GAYYEAN was a student at Lowell High School. Not even an adult would appreciate the risk if the depth of the pool is not marked. That's the crux of this case, the government. They would not appreciate, because if you're jumping in what you think to be, 2 feet and it's really 9, if it's not properly marked, they breach a duty to foreseeable plaintiff, which is Eddie GAYYEAN.
Can you remind me what the evidence is with respect to how the depth of the pool was marked?
What evidence? It was the report from the health department, and that's
In
also.
other words, did the area that's only 2 feet indicate 9 feet, or was there a 9 feet area that indicated that was only 2 feet?
It was not marked at all.
Oh,
yes.
Okay.
And so, in essence, Your Honor, or in conclusion, the trial judge, the lower court judge, erred in deciding that Eddie GAYYEAN was a child trespasser. And even if they decided that he was an adult trespasser, they still fail or breach that duty of care to Eddie GAYYEAN because of the knowledge that they had that the swimming pool was always kept unlocked and they did nothing to remedy the situation, such as having the depth of the pool marked, having the doors locked and secured from foreseeable plaintiff. This is why the laws were created.
Okay,
To protect
I think we have it.
Thank
We'll
you.
have to leave it there. Your time has expired. Attorney Janess for the defendants.
Thank you, Your Honors. May it please the court. Carrie Janess for the City of Lowell. The City of Lowell submits that the judge below was correct to find that Eddie GAYYEAN was an adult trespasser. There's no evidence on the record to suggest that he had any appreciation different than the average, ordinary, intelligent 17-year-old who would be expected to understand the pitfalls of open water or fire or any other.
Counsel, though, but wait. He's 17. Sure. So
yes,
I thought the issue was that he was still a child trespasser, but that there was no indication about him that would take him outside an ordinary 17-year-old, not that the judge found that he was an adult trespasser.
I believe the judge found that he did not fall under the child trespasser statute because the harm would have to come to him because of his age. And you can't say that because of his age, he, you know.
But let me push back just a little bit on
sure.
Because the question I have, I understand that the child trespassing statute provides an exception, and the restatement indicates that a child may reasonably be presumed to understand the dangers posed by water. But why is that not a jury question?
Well, there's no evidence. The judge essentially was serving as the trier of fact at the summary judgment stage and could only look at the evidence that was there, and no reasonable jury.
The judge cited in the cases that you cite in your brief, all of the appellate authority that I was able to find are cases where that question was put to the jury and then affirmed on appeal. I am not aware, and I didn't see in any of the authorities that you rely on that where there was a case in this posture where what a 17-year-old could be reasonably expected to know was decided as matter of law.
I thought that Davidson versus Metro District Commission was a summary judgment case. That's obviously the case that's most analogous to our situation, where
that was. I mean, I mean no disrespect to Judge Zabel, but that was a Superior Court judge who reached the same conclusion that this Superior Court judge reached. But that is not binding appellate authority.
Sure, no, it's not. I'm just you were asking for a case that we cited.
I'm asking for appellate authority for the where this was determined as a matter of summary judgment, as a matter of law.
That I don't have. I think the closest appellate case is the FABIAN Siri versus City of Lowell case from, I think, 1993 or 5, which that found, it was a jury case, but children of the age of 5 and 7 were found to be able to have an appreciation for the dangers of going into a pool.
Right. That was a question of fact that was found by a jury, which we don't have here.
Correct. Mm-hmm. Correct.
In addition, there is some evidence in the summary judgment record. One, the fact that Mr. GAYYEAN had only been in this country for a short period of time, and in fact was actually even attending summer school, and indicating a need to make up some coursework or something along those lines. Correct?
He was. It is in the record that he was attending summer school and that he was authorized to be in the building, just not authorized to be in the pool area.
Well, and I guess the question of the danger of water to a 17-year-old, I suppose, depends a little bit on the depth of the water, right?
I would imagine so. Although, I mean, that I think I would assume that most 17-year-olds would recognize that a pool is not a puddle, that it has some amount of depth to it, and
well,
if you know you don't know how to swim.
But if it's 3 feet deep or 4 feet deep uniformly for its entire length, a 17-year-old who's tall enough to have 3 or 4 feet go up only to their midsection would maybe not assume that they're going to drown in it, right?
Possibly, but I mean, it was certainly clear to Mr. GAYYEAN that he was not permitted to be in the pool, based on the record evidence of the police officer's report.
That's what makes him a trespasser. It's not what makes him an adult.
Right. I mean, it makes him making adult choices to attempt to take multiple paths to get into a place where, and I guess teenagers do that too. So
the narrow question that we have to decide, seems to me, the crux of this case is whether the judge was correct in determining as matter of law that at 17 years old, this decedent should be charged with an awareness of the perils posed by that pool.
I mean, to put it a different way, I can understand why the judge denied summary judgment to the plaintiff, but it's harder to see why the judge granted summary judgment to the city.
Well, the judge had to look at what evidence there was and, you know, whether there was enough evidence for any reasonable jury to conclude that he was other than an ordinary intelligent 17-year-old, and there wasn't.
No, but the difficulty I'm having is with the conclusion that an ordinary 17-year-old would understand the danger of the pool.
Understood. I think that, as I said, Fatun Theory said that a 5- and 7-year-old would understand the dangers of a pool.
In that case, the court said the jury could have concluded.
True. It was a jury conclusion, but
it was a question properly put to the jury, and the panel on appeal was not going to set aside the jury's conclusion to that effect. This is a different posture.
It is. But again, the jury can only review the admissible evidence that's on the record. Discovery was closed. There was no evidence on the record for the jury to look at to see anything different than an ordinary 17-year-old. And that's the basis that Judge Tutman felt that she could conclude that she could say an average ordinary 17-year-old.
Well, she said the answer is unequivocally yes. But her authority for that is framed in terms that seem to put the question for the trier of fact. And it's I guess one way of looking at it would be that she presumed herself to be that trier of fact on summary judgment. I guess I'm struggling a little bit to understand why that was appropriate as a matter of law. Certainly, a jury could reach the conclusion that you're urging, but the question is whether a rational jury must reach that conclusion as a matter of law. And in order for the summary judgment to be appropriate, that it has to be the case that no rational jury could conclude otherwise.
Correct. And I think that she felt confident reaching that conclusion because the record had been developed. The admissible facts were the admissible facts, and there were no admissible facts on the record that would allow a reasonable jury to reach a conclusion that there was no facts indicating he was impaired in any way or in any way unable to appreciate the risks that an ordinary 17-year-old was. He was taking SAT classes at night. You know, this is an intelligent 17-year-old. He did just move from another country a few months ago, but he had been at Lowell High School in the spring. This was the summer. He had some experience, which again is on the record as admissible evidence. And I think on that basis, with no admissible evidence to contradict it and discovery being closed and no opportunity for other evidence to enter, Judge Tutman felt confident that no reasonable jury could determine anything other than that he was an ordinary 17-year-old.
Do you want to respond to the plaintiff's alternative argument that even if we treat him as an adult trespasser, the city's conduct was reckless and therefore culpable?
Sure. That is an incredibly high bar. As you know, it requires a conscious choice of action to intentionally disregard a risk. There's no evidence of that. There is admissible affidavit evidence from this school's custodian as well as the operations manager from Lowell High School that all of those doors were kept locked all the time. Even accepting that in a res ipsa sort of fashion, clearly the city failed on that day to prevent unauthorized access through a door to the pool. That alone does not rise to the level of wanton, willful, or reckless conduct. Even, again, accepting, as Judge Tutman did, that the city would have been in violation of the confines of the DESI memorandum that was, again, hearsay, but referred to some CMRs that we can accept as applicable. And it's not per se negligence. It's not automatically willful, wanton, and reckless simply because the city failed on that day to prevent access. The city has admissible evidence that its policies absolutely were to keep all the doors locked, The city was not on knowledge of any other trespassers that summer besides this unfortunate incident. The city was doing, the record evidence is the city was doing everything it could to keep up with its responsibilities and to prevent unauthorized access to the pool. On that basis, the city's conduct does not rise to the level of willful, wanton, or reckless.
Was it before the judge that he was from another country, albeit he'd been here a little while?
I'm not certain if that evidence was properly before the judge, but it's not disputed by the city. If there are no other questions, I'm happy to rest on my brief.
Seeing none, thank you. Thank you both. The case is
Thank you.
submitted.
We are live.
We are continuing our hearing list with the next case on the list, case number 2020P 1198. This is a case involving the termination of parental rights, and I've reminded the parties that the case is impounded. They are to refrain from any references to the parties' names. Attorney Penta, you may begin.
Thank you. Good afternoon, Your Honor. May it please the court, I am Michael Penta, and I represent the appellate father. Request this court vacate the judgment finding him unfit and the decree terminating his parental rights to his daughter. Parental unfitness is not parental imperfection. It requires clear and convincing evidence of a grievous shortcomings or handicap that put the child's welfare much at hazard. And despite the allegations and findings concerning father's substance use, mental health diagnosis, housing, and criminal record, none of these establish a nexus to an inability to provide his daughter with minimally acceptable care. And we know this because the department was in the progressive stages of a reunification plan with father early on in this case, notwithstanding the existence of these issues. And we know too that he never endangered his daughter, quite the opposite, as the judge's findings are overwhelmingly positive of father's interaction with his daughters during his visitations. In addition to the lack of clear and convincing evidence of parental unfitness, it was a grave due process violation for the judge to shift the burden to father to prove his fitness in this case. And we know this too, because the judge made numerous remarks in her ruling and in her subsequent findings that father was, in a sense, presumptively unfit, but was given time to prove otherwise.
So, counsel, someone's showing the live stream. Can you?
Okay, we're live.
Okay, we will resume the hearing. We believe we've resolved the technical issues. Justice Henry, you had a question.
Yes, one of your colleagues has argued that the father was not determined to be unfit because he had work to do on the trailer, but because he was not forthcoming with the department, denied them access to the home for a significant amount of time, put himself in a position where he might be evicted. So what do you say to that?
Well, I would say to each one of those in turn that my clients, whether he was forthright with the Department of Law, doesn't elevate unconvincing evidence to clear and convincing evidence. It's the proof is somewhat in the pudding. There was no suspicions that he was abusing substances during their interactions with my client. In fact, it was quite the opposite. Most of the allegations are coming from anonymous sources, general assertions in court clinic record that didn't even release for 2.5 years after the case was filed. So the fact that there was this court clinic evaluation done, much of this evidence was probably available to the department through releases from my client, which he did provide to some degree. And the fact that this was not an issue where his substance use, even if he wasn't being completely forthright, although he wasn't denying it, I think it was just a degree of which of the accusations and the allegations, but to the fact that the evidence just simply wasn't there. And with respect to the issue of housing, again, I think they addressed in their brief that the issue with eviction, if you will, is that he borrowed money from his uncle. His uncle wanted him to pay it back, tried to evict him. And it was proven that my client was in fact the owner of the mobile home. So I think that sort of a red herring, if you will, that he was the eviction issue was resolved, and it wasn't really an eviction. It was more of a suit, if you will, for failure to pay back his uncle for money he allegedly borrowed to buy the home. I forget in the issue with the housing. So if we just take a look at the timeline with regards to that, and I don't think that seemed to be an issue that took on a life of its own. Again, early in this case, if we look at the timeline, the department was in the stages of a progressive reunification plan. He was having unsupervised visits with his daughter. He was on the verge of having overnight visits. He had a suitable bedroom for him in his home, notwithstanding the fact that it was under construction, and his mother had a suitable home who was living in the same mobile park with him. So the issue of housing became just, again, another somewhat, in my humble opinion, a red herring, because the department, the evidence that the judge relied on was an observation by the department like a year before trial. And then since that year, and in that year, they had a court investigator that went out and disputed what the department was claiming, exposed wires in the stove, for example. And my client is on the record that he invited the social worker to visit the home weeks before trial. And the social worker decided he would meet with him after the trial, which in a sense doesn't make any sense, at least with respect to gathering, up-to-date current evidence of his home. And my client just testified that he did have some work to do, as did the court investigator, but it was a cleanup. We don't terminate parents' rights because a house needs to be cleaned or needs to be reorganized. So the issue in that regard seems to be given far too much weight, if it's to be given any weight at all, and if it's not even stale evidence that it's being based upon. So I hope that answers your question.
Attorney Penta, you have in your inventory of the father's identified shortcomings, you did leave one element out that I found significant in reading through the judge's findings, and that was he seems to have a very volatile, violent temper, and has some issues managing his aggression when he gets angry.
I apologize, John. I believe I did include that as one of the elements or one of the factors in my brief.
No, you included it in your brief, in your oral recitation at the beginning of your argument this morning.
Oh, I'm sorry. I apologize. I kind of in I was including that sort of.
To me, in addition to his chronic substance abuse, his unstable housing, his extensive criminal history, the violent temper in assessing his fitness to parent seems significant.
And it could be if there was some connection to or establishment that it put him in a position that his child would be harmed. The judge doesn't make that connection. It conveniently relies on the department summarily stating that they believe it does. But the evidence, if you peel back the layers of the onion, none of this was done directed at his child or generally in her presence, but rather was done in the context in some issues. It is contextual. He did discuss this with the court investigator, and the court investigator concluded that a lot of this stemmed from a contentious relationship he had with the department, in large part based on one, their disagreement about his fitness and the services he needed, but two, he viewed somewhat antagonistic that they continued to refer to his daughter by the name that he tried so hard to change, and but for some, I guess, legal technicality was unable to do. So again, in context, these are contentious situations. The department isn't adversarial as much in these cases as they are trying to help the family at some point. And so, that's, I think the record sort of reflects more of that contentious relationship than any ongoing.
But his violence was not limited to his interactions with the department.
Now, the judge didn't make one finding that he got into a fight. But I don't think that I don't think anything really in the record expands beyond that from the judge's findings, beyond interaction with his social workers. I know there was a reference that he was argumentative with his lawyer. I didn't see anything in the record that would substantiate that. So, I mean, I think there were some findings, but the record itself doesn't substantiate a lot of those claims. There was, of course, contentious.
I don't remember the detail of his criminal history, but I seem to recall that there were some crimes of violence in that history as well.
But his criminal history all predates his daughter's birth. He had been on probation and successfully completed it by the time. So, the standard is current unfitness. And I understand that he may have had some criminal histories that are in violence, but he had no criminal charges as a result of violence.
The child was removed from the mother because the child tested positive for Suboxone at birth. And so the child really wasn't that old at the time. I realize that if we're talking about a period of 10 years, you could say he turned over a new leaf, but I guess past his prologue in some instances, and when you've got a history that extends over a number of years and a number of crimes, the mere fact that he's gone for a brief period of time without reoffending is the judge isn't compelled to conclude that he's no longer at a risk to the child.
Well, I disagree that the law is that incarceration itself does not permit a termination of parental rights, and my client clearly wasn't incarcerated. He has a criminal past. So to substantiate that this translates that he is sufficient evidence, a clear and convincing evidence of parental unfitness because he has a criminal history is contrary to the elements of.
Well, I wasn't talking about the mere fact that he had been incarcerated so much as the tie to his violent temper, his use of aggressive conduct in response to resolve situations that he didn't like. You initially responded to my question in that regard by saying that the record limited that tendency to his interactions with the department, and I guess I'm challenging the notion that his violence is simply limited to his interactions with the department.
No, I think it's fair that there's some other evidence of violence. For example, he did get into a fight with someone in his group program, but that is even assuming that without seeing that the anger issue was compelling in terms of its existence. This is one of, as you mentioned, 4 or 5 factors that the judge cited to in supporting a termination of parental rights. And the elements of substance abuse, for example, doesn't have a connection with the fact that he was in fact having successful visits with his daughter. So it's really kind of all baked in together, and it's hard to probably surgically remove one of those elements from the remainder. But notwithstanding,
you do seem to agree that he was terminated from one of the substance use counseling services because of violence against another participant?
That's correct. That's what the record supports. That is.
Was he? There was a contention in one of the briefs that he was actually terminated from 2 services, or was it that he was terminated from one and couldn't get into the other?
I believe that's the character. He was terminated from one and had difficulty getting into another because he was terminated from the other service. That's my understanding. So he was terminated from one. But again, Your Honor, the judge, I think, in terms of her finding and in terms of her ruling, do make some troubling remarks to this panel. That
did the father object to any of the remarks that were made in the court hearings?
Well, none of them. Oh, there was one in the pre-court hearing, and I guess that can be explained away. I think the Department or in Children kind of put it in the context of that, as I have a different reading of it, but I could see that it wasn't objected to, and maybe trial counsel didn't have the same reading of it as I did. But I don't know how you object to the findings of fact that come out or issue subsequent to it. I think that's what the appeal is for.
Understood. But your colleagues argue that that basically the department did come forward with more than sufficient evidence that the father was unfit, and if he wanted to offer evidence, he needed to, for the judge to consider that, he needed to do so. So why are they wrong about that?
Well, he's not obligated to present evidence, notwithstanding the claim to the contrary. But in this case, I mean, I would overlook that the judge on a number of occasions when she had time to deliberate and think about it, and for references just in her findings alone, that father was given time to prove his fitness. And I think that is representative of either a prejudgment of father or a bias towards what he needed to do to allay the allegations from the department. And those are troubling because it is inherent in those findings that, or not even inherent, explicit in those findings, that the judge was essentially delaying the proceedings to give father time to demonstrate his parental fitness. I mean, she says that on 3 occasions in her findings of facts. And
based on a showing that the department already had made.
But that showing was to be made at trial, not pre-trial. So either the time was given to prove parental fitness because there was an inherent prejudice against him going into trial, or there was at the time of trial a prejudice or a prejudice in terms of prejudicial remarks that that was done so he could demonstrate his fitness. So it was either he was found unfit prior to trial or failed to prove his fitness at the time of trial, both of which constitute grave due process violations in the shifting of the burden from the department to my client. And if there are no further questions, I'll rest on my brief.
Seeing none, we'll hear from the department.
Thank you. May it please the court. Jennifer Kernan for the department, asking that this court affirm the decrees of the court below. Specifically, as the judge's findings indicate, there is clear and convincing evidence of father's unfitness. And we've covered essentially a laundry list.
Let's just stop though. Right before the trial, the judge makes a comment about the father proving his fitness. And I don't think the department stopped and said, you know, in today's parlance, I don't think the department was an upstander and saying, let's just be clear, judge, it's not his burden, it's our burden, right?
Correct. I believe Your Honor is referring to the January 9th, 2019 statements. And I'm sorry, was that the conclusion of the question?
Well, he's saying that you're sort of darned if you do, darned if you don't, because either the judge had prejudged the case or she shifted the burden of proof. And I guess I'd like to understand why he's wrong about that.
Well, he's wrong if you look at the full statements that the court made. Specifically, the lower judge stated that if this is going to trial, all of this needs to be taken care of, I believe referring to releases. But she said, if you're presenting a case against what the department's saying, and the full context of that statement is important. It illustrates that the judge is simply giving father an opportunity or reminding father that he has the ability, not the obligation, but the ability to present a case against the department. And if he chooses to do that, he's going to need some evidence. So there's no burden shifting, especially not in the January 9th, 2019, those pretrial statements, nor is there any burden shifting indicated in the December 10th, 2019 post-trial statements or in the judge's findings. All of the judge's statements need to be taken in context and read in full, essentially. I believe that there may be some phrases or some words when taken out of context could possibly indicate burden shift. However, when read in context and in conjunction with all of the findings, especially the judge's conclusions regarding the factors of General Laws 210, Section 3 that were very detailed, there is no burden shift here.
So he also makes a different argument that that basically that the court sends out this clinician who says the stove is there, there's no loose wiring, but the judge seems to find to the contrary, or that there's still a problem with the home. What are we supposed to do with that? Because the court evaluator is supposed to be a neutral, and the department seems to have refused the invitation to come prior to trial.
First, I'd like to address the department's apparent refusal to visit father. That's not actually the case. The social worker testified, I think it's on the transcript, volume 8 at pages 209 to 210. The social worker testified about his efforts to contact father to schedule some of those visits. The social worker said that there were numerous letters and calls to father to schedule that visit. And it wasn't until, I believe, a week before trial that father actually contacted the social worker. And at that point, the social worker's availability was somewhat limited. It's understandable that father would want the social worker to come out to visit his home before the trial date. However, father had been unresponsive to the social worker's attempts to do so before that case. And with regards to the court investigator going out to the home, the court investigator did notice that there was some disarray. And in the court investigation, there was included a description, a very detailed description of the house. There were rotting floorboards on the porch. The interior floor of the trailer home was simply bare wood. There were sheets hanging over the windows. And the investigator noted the general disarray in the trailer. And again, this is a child who was 3 years old at the time of trial. So generally not a very safe place for that toddler to be. Father himself.
Is that what the court evaluator concluded?
No, that was not a specific conclusion of the court investigator. But father himself noted or said to the court investigator that his home wasn't ready. He told the investigator that if he knew that the child were coming home, he'd have the home ready like that. So even by father's own admission, the home wasn't ready for a 3-year-old child. And on top of that, the home is just one of the many issues that we've talked about, specifically father's substance abuse, his volatile behavior. And father argues that there's.
Did the judge rely on his criminal history as one of the foundations for the decision?
I believe so. And it was not improper for the judge to do so. And it was in conjunction with all of the other issues. And as Chief Justice Green noted, the father's volatile temper is demonstrated by his records. Specifically, I believe that there were at least 4 harassment prevention orders on his record and 4 restraining orders. And the 4 harassment prevention orders were against father. The plaintiff on those was his family friend. I believe the last name starts with an S, so Mr. S. And one of those happened during the time of father's, quote unquote, eviction. And for the restraining order, I believe his mother was the victim or the plaintiff rather, on 2 of those restraining orders. So father's volatile behavior, his criminal history, his substance abuse history, which the department did not know entirely about until that 51A was filed in November, I believe, of 2017, which led to a conversation with father's probation officer, and the extent of father's substance abuse was revealed at that time. And father had been non-compliant, providing releases for the department to access screens. And for those reasons, there was no burden shift. The evidence is clearly and convincingly supports that father is unfit. And for anything else, I'd rest on my brief.
So just one point of clarification, the judge did conclude that chapter 210, section 3C, I think it's 13, about incarceration or the father's criminal history, that the judge relied on that and that was in error because the father was not incarcerated or soon likely to be incarcerated. Do you agree that was an error or not?
I don't think that was an error, Your Honor, because it's not solely incarceration. And although father did spend some time incarcerated and actually on parole, and if I may continue to conclude the answer.
Please.
Father did spend some time on probation. I believe there may have been some violations of probation, but that coupled with his volatile behavior presents opportunities for father to be incarcerated or at least removed from being able to care for the child. So no, I do not think that was an error.
All right. Thank you. We'll hear from counsel for the child. You'll have to unmute yourself, Attorney Krasner.
Thank
And
you.
just for the record, the screen reads Heather Krasner, but this is Attorney Sherry Krasner, correct?
That's correct.
Okay,
Thank you. I apologize for not changing that. May it please the court, I'm Sherry Krasner on behalf of the child, substituting my judgment for my 4-year-old client. I ask that this court affirm and affirm promptly. The judge committed no reversible error here. My client, as you know from the record, has been in state custody since she was 3 days old. She deserves permanency and she deserves it as quickly as possible. I think the Department of Children and Families did a very good job in answering the court's questions about the burden of proof and that there was no shifting, but I just want to add a few comments to that. First of all, at the pretrial, the issue was not raised. Father was represented by counsel when those comments were made. No objections were raised, so we could deem that waived. And Leland tells us that. Also, too, the judge in her findings, and specifically in conclusions number 3 and conclusion 20, she talks about the burden of proof. She knows, she understands the law, she understands upon which party the burden rests, and she concludes that the department met that burden with clear and convincing evidence. So again, in terms of context, putting what the judge's clear pronouncements about the law, I think that erases any suggestion that she ever shifted the burden at any time to father to prove his fitness. Father's other argument here.
Does the child have any specialized needs?
It talks in the adoption plan how she had really met many of her milestones with early intervention, and that the most important thing that was necessary was to have a caregiver who could be alert to some of more subtle developmental problems that could occur, and that she needed a vigilant caregiver who could pick up on those nuances as opposed to any particularized special needs. But again, I would suggest that she was at that point because of the care that she got in substitute care, including those people who had fostered her for 18 months at the time of trial, who were most likely going to be the adoptive resource and who had arranged for this child to be in early intervention to correct any deficits. As I was saying, father's other argument had to do with the sufficiency of the evidence. And in this case, there were 78 findings of fact, and there were 44 conclusions of law, many of which were supported by additional facts. And father does not say that any one of those findings of fact was clearly erroneous. And as this court does not sit to review the evidence de novo, this court has to accept all of those findings as true. And I talked in my brief about how what father pointed, he was trying to make the argument that really boiled down to that father's problems were bugs and not features. And I wasn't trying to be glib when I was saying that, but I think what the judge did is that she very skillfully put together the father's failure to consistently visit with the child, father's failure to perform any services, father's expulsion from drug programs, all the things that father did. She artfully put those together and said that this is a pattern. This is about a man who always deflected, who always, I had a positive drug screen because somebody put something in my drink. I got into a fight with somebody at my drug program because he said something he shouldn't have said. I'm only having supervised visits because an old girlfriend was bitter and she turned me in to DCF, that there was something about this pattern to never take responsibility. It were all those things, when you put those together, that's what rendered this father unfit. And I would, again, refer the panel to conclusions of law 4, 8, 9, 12, 15, and 38, where the judge does weave together those facts that she found with her overall conclusions about father. I will say, Your Honors, that I slightly disagree with DCF. I do think that the judge may have committed error with respect to that factor in section 210, General Laws 210, section 3 regarding father's criminal history. I don't think the record supported that father had a likelihood of being incarcerated. However, that the fact that she may have erred there is not critical to her ultimate finding, because there are 13 factors in section 3. She found 8 of them relevant to this case. So even with that factor taken out, there's still 7 factors fully supported, not challenged by father, that support the ultimate termination judgment. Also, too, the court had some questions about father's volatile temper. And I think that this case easily could be distinguished from a case such as adoption of Zoltan, where the court found reversible error, where there were 2 discrete episodes where the parent had expressed her anger and her frustration in those contexts, but had never harmed the child. And yes, admittedly, in this case, there's no evidence that father was ever inappropriate with the child or ever displayed his volatile temper in front of the child. But this was not a case where there were just 1 or 2 discrete episodes. In addition to showing his anger in front of DCF, he threatened his probation officer. He threatened a person in his group. He had fights with the mother of this child while mother was pregnant. So for the judge to draw the inference that father would not be able to contain his temper, even though in his few visits with the child, he hadn't manifested that, the judge's inference was not unreasonable and certainly shouldn't be questioned by this court. If there are no other questions, I will rest of my brief, and I thank the court for its time.
Seeing no questions,
We are live.
we now reach the 6th and final case on our hearing list today. The case number is 2019 P 438 Barry Finkel versus Margaret Liz Hunt and others. Oh, one of you, it sounds as though one of you has the YouTube channel. I would ask you please to mute that.
That was me, sorry.
Okay. All right, Mr. Finkel, you may begin your argument.
Thank you, Your Honor. This is my appeal from the allowance of 2 anti-SLAPP motions. And what I say is the judge made very serious error in not operating the Duracraft test. She never found that the lawsuit is based on petitioning activity, and certainly not petitioning activity of trustees.
We just lost a lawyer.
Mr. Finkel, I'm sorry, we've just lost Mr. Bernstein.
Even attempt in an affidavit or any other evidence before the court to show that that the individuals, my fellow owners in the condominium, were ever the trustees. And in fact,
Let me ask you that question, if I may, Attorney Finkel. I'm
Sure.
referring now only to your co-owners, the other unit owners. What would you say if we were to agree, or if there had been a finding that they are the trustees of the condominium, which I know you disagree with?
yes,
But if that were the case, then would the activity be that they engaged in be properly described as petitioning activity?
no. Well, it's hard. I mean, it's hard to say, because that's such a big if. What they did was,
well, what they did was they filed certain certificates, right, with the registry. They engaged the services of a lawyer. they presumably paid bills on behalf of the condominium. So,
Well, I don't know about that.
well, there's an allegation that they used monies for that, and they also allegation that they obtained monies from your lender.
Yes.
And I don't pretend to be remembering every detail right now, but that activity, if which I know you don't agree with, if they were the trustees of the condominium, would that activity fall within petitioning activity?
Would fall within, I'm sorry, I didn't hear the very last thing you said.
Would that be described legitimately as petitioning activity?
No.
And why not?
Even if they were the trustees, this lawsuit wasn't filed because they didn't know how to become trustees. That's not really the problem. The problem is that when they became trustees, on the first day that they became trustees, and that they say they did in 2012, they said there was already an assessment in the past that I hadn't paid, and that I owed them not only an assessment from the past, but approximately $20,000 in legal fees for the counsel to the trustees.
Isn't that appropriately an affirmative defense to the collection action? I mean, the fact is that when they initiate suit to collect monies owed,
Yes.
that is petitioning activity, right?
Well, that is, well, okay, that's petitioning activity. I'm not saying that they sued me now 4 times, 3 times before this lawsuit and once after. I'm not saying that there was no petitioning activity, but in order for an anti-SLAPP motion to lie, my lawsuit has to be based solely on that petitioning activity. And
So
in
what's
fact,
the non-petitioning activity that you say your lawsuit is based on?
well, they took over the entire operation of the condominium. They filed false certificates in the registry of deeds, which the statutes say that third parties can rely on. They
but those are all, again, those your contention that that's what they did, it seems to me, is properly framed as an affirmative defense to their claims in the suits that they brought. What you've done instead is brought an action against them for initiating those suits.
No, I brought a lawsuit. I disagree with that. I brought a lawsuit for them claiming in lawsuits and not in lawsuits that they were the trustees of the condominium. They're simply not.
So does your suit include a claim or seek a declaration that they are not trustees of the condominium?
Well, I asked for a declaratory judgment. Now, as it happens, they sued me a 4th time since this lawsuit, and that lawsuit ended when I got a summary judgment saying that they weren't the trustees at the time of the summary judgment, and that they had never been the trustees, and most importantly at all, that no one had ever been a trustee of the condominium, which is important because if nobody was ever a trustee of the condominium, there could be no assessments because it takes trustees not only to collect assessments, but to make the assessments. And there never was.
What judgment are you referring to?
What, again, I'm sorry, I didn't.
What judgment are you referring to?
There's a 4th lawsuit that they filed after.
Is that before us?
I'm sorry, again, I'm sorry.
Do we have that?
No, this was filed after this lawsuit, my lawsuit.
So
But
why
it
can we
ended in
consider
summary
it?
judgment.
I think Justice Henry was just asking, and I have the same question. How can we consider that?
No, I'm not I'm not asking you to consider that. I'm just saying that my claim that they didn't demonstrate to the court that I was suing them for the petitioning activity of the trustees. You say, if trustees had sued me and they were trustees, that would be petitioning activity. But people who are pretending to be trustees, I don't think it can be said that my lawsuit is based on, certainly not solely based on, the petitioning activity of trustees who don't exist.
So,
And
so Marks and Hunt, though, they argue that by withdrawing your count for willful malfeasance of a trustee, you're acknowledging that claim was barred as a matter of law. So what,
well, I thought better of it. My case was always going to rise and fall on whether or not they were trustees. I did put a count in for breach of fiduciary duty, but my heart wasn't in it. It didn't. I didn't want to. I just didn't want to do it. I withdrew it. But that lawsuit is based on the trustees' lack of fiduciary duty, which is also not a SLAPP suit by case law. It's one of those things. There's lots of things that aren't SLAPP suits.
Mr. Finkel, let's assume that the building had a flood and the common area was damaged and somebody paid those bills, and that you're right, there was no trustee at that time. And that for whatever reason, you all couldn't agree. And so later, by lawful process, these two people were named trustees. Can they then go back as trustees and make an assessment for that money spent?
I don't know, Your Honor. I think we're going to find out, because just 2 weeks ago, they did become trustees. After 8.5 years of claiming so, they are now the trustees.
Understand, sir, is what your long-term plan here is if they can turn around and impose an assessment that was incurred by the condominium building to repair common area expenses. Because this is not your first trip to our court, and I'm puzzled as to the long-term strategy here.
The other time I was here, the court, it was for Harmon Law Office's appeal from the denial of a SLAPP suit in the same case, and this court said it wasn't a SLAPP suit. The question, first of all, assessments are prospective. According to our rules, the trustees create a budget for the next fiscal year, and then assess, that is, notify each unit of their respective shares of the next budget. And that's called an assessment. And that's what trustees make and have to pay. Before, for 12 years, we didn't have, no one even claimed that they were making assessments. We handled everything by agreement. We had an agreement to pay for the flood. In fact, we paid for everything except for one bill. And we all agreed that we weren't going to pay that bill. We had a problem with the vendor. We did everything by agreement. But then we three couldn't agree on how to divvy up that bill, the part of it that was owed. That amount of money was very small. It was there was no opportunity. It was impractical to litigate that matter. It had to be resolved. It had to be settled. But instead of doing that, they hired a lawyer who said, you know, that disagreement was over an assessment and you owe me $20,000 for legal fees because they're the trustees. And of course I refused to pay that. What can I do? I refused to pay it. And they filed three lawsuits against me, all of which were dismissed. They could never prove that they were the trustees. And I say, how can the court say that I'm suing the trustees for their petitioning activity when in fact they are not trustees and there were no trustees? How could trustees who don't exist have petitioning activities?
Well, suppose they weren't trustees, but they were petitioning.
Well, if they had sued on the disagreement over how to pay for the flood, there wouldn't have been a problem. They chose not to do that. They chose to make that lawsuit into a statutory breach of my obligation to pay legal fees, to pay assessments and legal fees. And I said,
go ahead.
You're wrong. I can't do that. How can I possibly pay you $20,000 for representing trustees who don't exist on an assessment that doesn't exist? That's what I said to them then, and that's what I've said to them all along. And they've never been able to prove in court that they were the trustees. How could they have petitioning activities? That's the Duracraft case. They had to show first that the suit was about petitioning activities. The trustees didn't even exist.
So then they argue that you're precluded as a matter of law from disputing the fees because you should have paid them and then sought a judicial determination. And I take it your response back was you didn't have to pay anything because they weren't imposed by trustees with lawful authority.
That's right. 1A, 3A, Lord knows, has enough teeth in it. And those cases, the blood case and other cases like it, start the decision, and all those cases say the duly appointed trustees made an assessment. Well, fine. If my neighbor says to me, I'm a trustee and you owe me money, I don't have to sue them. They have to be the trustees to come under to be able to sue me, and they weren't.
What's the process for becoming a trustee in your situation where you're saying basically the terms of the trustees expired and nobody stepped in and you all got along until you didn't?
Any owner, any single owner, and this is the next line. The next line after it says that trustees have to sign a certificate says that if there are no trustees, any single owner can come into court and say to the court, we have no trustees to conduct the appointment of new trustees. Please appoint trustees. And that in fact happened a couple of weeks ago.
Okay, Mr. Finkel, your time has expired. Unless there are other questions from the panel, we'll move on to hear from the defendants. Okay. Mr. Nisha, are you going first, I gather? You're gonna need to unmute yourself.
I apologize. May it please the court, my name is Chris Nisha. I represent the defendants Lovenberg and Associates and Melissa Poland as the attorneys for Nancy Marks and Lise Margaret Hunt. Notwithstanding dispute of the facts as they were just reiterated by Mr. Finkel, my main focus in the brief, as you know, and throughout this whole thing is, and I would reiterate this in addition to what I put in there, is that as far as the anti-SLAPP issue goes, he says that the judge erred in not doing a test. I don't know from the record that the judge didn't do a test because there's no transcript. There's no, I mean, from my position when we were in the hearings, we had a very in-length hearing. couple different days on this issue. And afterwards, the judge made the decision that she did in regards to that. As far as when it comes to.
You can't point to something in writing in the record demonstrating that the judge applied the test, right?
Correct.
Okay.
But I make that same argument that he can't, that they didn't, but yes, yes.
Right, but so
Correct.
assuming we infer that the judge properly instructed herself and she applied the test, what proves that his suit is based solely on petitioning activity? What in the record would support that?
Well, as it relates to Lovenberg and Poland, I would argue the fact that they acted throughout the entire time that he mentions in the fact pattern here as counsel for these individuals. Nothing as far as any individual action they took against Mr. Finkel. They're not parties to the lawsuits. They're not taking any action against him personally. They solely represented these individuals as owners of the units in a private dispute that continues to this day about the common expenses and the allocation of costs for this condominium. So he just went at length about 3 lawsuits that he discussed with you guys as far as the basis for what happened. That, from my understanding, from their motions and just relation in my experience, is that was their petition activity, not just as trustees, but as owners of the units who have been paying the normal costs. We're not talking about extraordinary fees. We're talking about the bare minimum water, sewer, insurance costs that over the years that he just, because there's no trustees, he feels he has no liability in any other sense. Unjust enrichment contract, which are also being brought up.
Is he, if I understood him correctly, he was seeking in this lawsuit some sort of legal determination that they weren't, at least up until the point of filing lawful trustees. Do you agree with that, or you disagree?
Well, I can only look at the pleading itself. And my first response to that is he was a party in the other 3 lawsuits and filed an answer in one and a motion to dismiss in another, and then just didn't respond in the third one that he's referring to. But he was allowed to participate in all 3 of those, never brought any counterclaims, never brought any affirmative defenses, never brought anything seeking to be any declaration of who was or was not the trustees in those petitioning activities. And then come fast forward to his lawsuit in the latter half of 2015. He then brings this lawsuit against everybody under the sun, claiming all of us have some role to play in this and have liability. And as far as Lovenberg and Poland goes, I don't see from his brief anywhere that would go beyond or would refute the judge's order that it's privileged, that they represented him as absolute privilege as attorneys for these individuals. And that's my concern with this appeal as it relates to Lovenberg and Poland, that the complaint itself alleges that they did this or did that, but in the entirety of it, he's clearly admitting and alleges, and in his motion he admits it too, and he just said it in his argument, that they were acting as attorneys for Marks and Hunt throughout the entirety of this situation. So how all of a sudden do they have individual liability? That opens the door for every lawyer out there who files a lawsuit on behalf of somebody.
Isn't a claim of litigation privilege separate and distinct from the status of an anti-SLAPP?
Correct, but that was raised in the motion to dismiss, and in the judge's order, she says that the action is privileged. The order as it relates to Lovenberg and Poland says, after review and hearing, this motion is allowed as defendant's counsel's actions are privileged. And that was one of the motion to dismiss was not strictly anti-SLAPP. We filed a motion to dismiss under 12B and also in regards to the privilege and also the anti-SLAPP. And so
what is your position in terms of what the judge did? You're saying that the judge actually dismissed Mr. Finkel's case against your clients as a result on a 12B6 motion, not on a special motion to dismiss?
Well, going back from what she says, from what I read, is their actions are privileged, and this lawsuit says to them is precluded by the anti-SLAPP statute. So
where are you? Can you give me a record citation for that?
I'm sorry, Judge. What?
Where are you reading from the record?
I'm sorry, that would be on page, from the record appendix of page 232.
Okay. All right. Anything further?
If there's nothing further from your honors, I would rest on the pleadings. I would just say this, Judge, you may all, or at least one of you have seen Mr. Finkel before in regards to this matter, and this has been going on for years, in which it's a simple 3-unit owner condominium. These are not nefarious unit owners going after for all sorts of costs. All they've ever wanted is to have their costs covered. Mr. Finkel, look at this appeal alone, is 5 years old. Mr. Finkel has consistently said to me and others personally that he intends to drag out every lawsuit, every action that he can, and make it as costly as he can, and include every party he can to deter any action against him. And this is just an example of that, just from the record alone on this appeal, how long it took to finally get before a tribunal. Notwithstanding COVID, I understand, but I would implore you that at the end of the day, there was no reason to file a lawsuit against Lovenberg or Poland, notwithstanding the other attorneys involved in other parties. And I would just ask that in considering not only my brief, I would just also ask, just please do not reward them for this type of behavior that has been ongoing. Thank you.
That brings us to the final presentation, Attorney Bernstein.
Yes, thank you. Good morning, Your Honors. May it please the court, John Bernstein on behalf of the appellees, Nancy Marks, Margaret Lease Hunt, and the trustees of the Goldsmith Arboretum Condominium Trust, refer to them collectively as the trustees. The lower court judge did not abuse her discretion or err in allowing the trustees special motion under 231-59H, the anti-SLAPP statute, and we ask that the court affirm that ruling. And while the court's decision was brief and to the point, I think the record demonstrates that the legal issues involved in the facts before the court were extensively briefed and carefully considered by Judge Fahey. And just briefly on this point, the record demonstrates that there were a lengthy memorandum submitted, 2 separate hearings, a motion for reconsideration, a separate motion by the—
What's the record evidence that the sole basis was petitioning activity?
Well, the judge's decision was brief and doesn't, and I think as mentioned by the justices previously, that you can infer, from her decision that she did consider, the facts and the legal application of the special motion. And the point I was making is that, that through all the many arguments, the multiple hearings, that this issue was properly vetted and considered by the court in multiple times.
No, but the question is, we don't have any insight from the judge herself in the order. I think what Judge Henry is asking you to supply is that explanation.
Okay.
What is it in the record that allows us to conclude that that the plaintiff's complaint was based solely on your client's petitioning activity?
Sure. And that would be consideration of the underlying petitioning activity, which was the previous 3 lawsuits, the Suffolk Superior Court action seeking the injunctive relief, and also the 2 BMC West Roxbury actions, which were taken to collect unpaid condominium fees. The fact that all these actions were brought in the name of the trustees, not by the unit owners directly, and that the trial court judge, in evaluating all this evidence and considering the petitioning activities, found that it was based on these activities alone, and there was no substantial basis other than these activities. On that point, I would point out, as I mentioned briefly in my brief, that in the appellant's brief on page 9, while Mr. Finkel disputes the trustee's authorities and actions, which he did, which was the basis of his complaint, Mr. Finkel admits, and I quote here, all of the claims Finkel makes against them stem from the fact that they have exercised GL 183 authority, close quote. By his own words, indeed, admission, all of the claims arose from the exercise of the 183 authority, which is the petitioning activity asserted here, and therefore, by the appellant's own words, all the claims were based on same, and therefore there cannot be, nor is there any substantial basis other
But that
than—
would only be if we were to accept the fact that your clients are the trustees. So I mean, I'm going to ask you the same question I asked Mr. Finkel earlier, and that is, where is that in the record? And if we were to find that they were not the trustees at the time that this lawsuit was filed, where does that take us?
Okay, sure. For purposes of the special motion, it's not a full, trial as to every issue raised. It's more of a preliminary review of what the alleged petition activities were.
But they have to be the trustees in order for this activity to be considered petitioning activity, correct?
To a certain extent, yes, but I think in consideration of the special motion, I don't think a final determination was necessary.
I thought you said no earlier. I thought you said it didn't matter whether they were trustees, if they were just lay people who had legal counsel, but who did the wrong thing, but they didn't know that they were still petitioning.
I'm not sure I made that point earlier. Maybe someone else did. I think 231-59H does not require or mandate that there be a final judgment of a court action as to the underlying petitioning activities. And I think the evidence that was considered by Judge Fahey was that all the actions were filed by and in the name of the trustees, not the individual unit owners. Second, that for purposes of those underlying actions, and specifically in the Suffolk Superior action, there was a determination on the preliminary injunction and a preliminary finding that that they were trustees, and Mr. Finkel was enjoined from interfering with the repairs and the painting. And then the two BMC West Roxbury actions, Mr. Finkel's mortgage company, Green Tree, did step in, and under the requirements of his mortgage, they can step in and determine and pay a valid assessment. There was no final determination in all those actions, but I would submit that is not required. Mr. Finkel had the opportunity—
I guess what I'm trying to understand is whether it seems like that the condominium, in the absence of an agreement of the owners, there's going to need to be a legal declaration about who was trustee and when, or that there were no trustees. If that's what he's seeking, at least to the extent that's what he's seeking, yes. I don't understand why granting the motion would be proper. It may be that granting the motion as to all the other counts is proper, but that you do at some point need somebody to determine who was a trustee or not when.
Right, yes, Your Honor. And I think the venue for that was in the other underlying actions, the BMC actions and the Suffolk Superior Court action, in which he had the opportunity to challenge the rulings and what occurred there, but he decided and failed not to do so.
And is that because they would have been a compulsory counterclaim?
They may have been a compulsory counterclaim, or it could have, as was referred earlier, whether it be, I see my time is up, but if I may finish my answer, affirmative defense or compulsory counterclaim, that was the venue and that was the time to do that. And my final point is that his complaint, the latter action, follows from and arose from the former action, which we would submit was the petitioning activities, the three prior lawsuits brought up by the trustees. Thank you.
I just
May
have
I-
one question, if I may.
Sure,
Go
sorry.
ahead. No, Justice Henry, I'm sorry, I didn't mean to interrupt. Go ahead.
No, you can go first.
Oh, okay. What about the fact that according to Mr. Finkel, at least one of those lawsuits was voluntarily withdrawn before he had the opportunity to determine whether or not your clients were the trustees?
Right. With respect to that, the matters were dismissed, but that didn't preclude him, from filing whatever he wanted to file there. It's not like, I think in the initial Suffolk Superior Court action, I believe that was filed back in 2000. I don't want to misstate here. In August of 2013, and the injunctive relief was issued in late August or early September of 2013. The case wasn't dismissed, I believe, until April of 2014. And in the other matters, the first BMC case, he filed an answer.
Okay, I can follow this. In other words, your point is that there was time to have raised these as affirmative defenses or counterclaims.
Absolutely. And he chose
Henry,
not to.
you had a question.
Yeah, so what I was just trying to understand is if you're, I guess, saying that each of those underlying actions was resolved one way or another. And what I'm trying to understand is this lawsuit, is your understanding of this lawsuit is that he's seeking damages for those lawsuits or costs that were incurred because of those lawsuits?
He is seeking damages arising from his position that the trustees didn't have the authority to do what they said they did, which is to get the injunctive relief, to file the actions, to collect the unpaid condominium fees. That is, the gravamen of his complaint, and is based on the trustees, which I understand he disputes, prior actions.
I think we're gonna have to leave it there.
Thank you.
Thank you all for your argument. That